And good evening, everyone. This is Dr. Michael Huffman. Welcome to the We the People podcast as the Virginia Assembly of Independent Baptists fights for your religious liberty at the Capitol in Richmond. Yes, I am in a suit tonight. I think this is the first time that I have been in a suit. I am very uncomfortable. I've been in this suit since about 6 o'clock this morning. But I flew in here from the Capitol in Richmond and came right into the studio and to sit down and do this podcast. Well, thank you for joining us tonight. We've got a lot of things that we want to cover. And I want to remind everyone, I was on the phone earlier this evening with Dr. David Gibbs from the Christian Law Association, and he reminded me of something that I wanted to remind all of our viewers of tonight. He said, we are not called by God to win. We are called by God to stand. And so that's what VAIB does, is that we stand for your religious liberties. And so that's why we fight. That's what we're going to do. God hasn't commanded us to win every battle. He's just commanded us that we stand. I want to remind everyone while you're here with us tonight of our website. It's www.vaib.org. And there you can find all about the Virginia Assembly of Independent Baptists. You can find out about me. And you can call 804-960-4014. If you have a comment or a question, you can call that number 804-960-4014 or email me at director@vaib.org. A lot of exciting things going on with the Virginia Assembly of Independent Baptists, and we're so thankful to the Lord for the opportunity that he's given us. I was thinking as I was coming up the road, I really do like my job. I'm one of those fortunate people that are able to say that I like my job, and I'm giving the thumbs up, thumbs down by my producer over here, Zachary. So that's either telling me to hurry up or slow down. I'm not quite sure what that is, but thank you for joining us tonight. I do want to remind you all of our rally. We have a Operation Hope for Virginia is a rally that we're putting on December the 2nd. It's beginning at 1 p.m. and going until 3:30 p.m. at 8659 Staples Mill Road in Henrico, Virginia. We're having the meeting at the office complex of the Virginia Christian Alliance, run by a good man down there, Brother Don Blake. And so we're looking forward to having a good time there as well. That's going to be, again, Tuesday, December the 2nd, beginning at 1 p.m. and going to 3:30 p.m. And what we want to do in that rally is we basically want to encourage God's people. Uh, it goes without saying, the election didn't go our way, but we want to encourage God's people that God is still in charge and he's still on the throne. And we want to encourage you all that God is still in charge and he is still in control of everything that's happening. It is a free event. There's plenty of free parking, and there's going to be light refreshments there. And although it's free, we do need you to register so that we have a good count of the people that are coming. To register for that, go to our website, www.vaib.org. And if you will look to the left of that website, scroll to the bottom, you will see a tab that says Operation Hope for Virginia. Just click on that tab, and that will take you to the registration form. And just click submit. Let us know your name and your email address and how many people are coming, and we will get you registered so that we know you're coming. Looking forward to having you. Again, that's on December the 2nd, beginning at 1 and ending at 3:30. Well, we got a lot of things we want to cover this evening, and we've got just a short while to do it. But I want to remind you of the election is now behind us, of course, and I want to remind you of what our Constitution and what our Code of Virginia, the Constitution, Article 2, Section 7, and then it was Article 2, Section 7 of the Constitution was codified in Section 49-1. And what that is that is the oath that each person that is going to represent their district must take. And it basically says this: I do solemnly swear or affirm that I will support the Constitution of the United States and the Constitution of the Commonwealth of Virginia, and that I will faithfully and impartially discharge all the duties incumbent upon me as a member of the House of Delegates of Virginia according to the best of my ability. So help me God. With every day, folks, that I sit in session, in every meeting that I have, I see in real life many of those promises that are made in that oath uh, not taken very seriously. I see constant violations of the Constitution of the United States, constitutions of the Commonwealth of Virginia, and I see constant violations of our code. There's a video I want to play for you. And what it is, it basically shows that our governor elect, Abigail Spanberger, does not care about religious liberty. There's already talk. There was a bill that our now Lieutenant Governor elect Hazala Hashmi patroned that was the assisted suicide bill. And there's already talk that they're going to try to bring that bill back. And the person that was asking Spanberger the question about religious medical facilities, if they want to claim religious liberty, I want you to notice in this video what Abigail Spanberger said in answer to that question.
Some religious healthcare institutions, most notably Catholic health institutions and systems, routinely place themselves in the middle of the doctor-patient relationship and prohibit their doctors from informing patients that medical aid in dying isn't even an option. What are your thoughts on legislation that would legalize medical aid in dying? And more generally, what are your thoughts on permitting religious healthcare institutions to dictate what their physicians are allowed to discuss with their patients?
So I support, and I would support, legislation that legalizes the right to die with dignity of a person's choosing, and that would include allowing for medical providers to provide prescriptions for life-ending prescriptions. I oppose the ability of religious institutions to put their religious-based ideas on individuals and their healthcare choices and options. I believe that we should trust people to have relationships with their healthcare providers that lead them to make strong decisions based on their medical practices, and I do not believe that people should have the option to allow their own personal beliefs to dictate the type of medical care that they are providing their patients.
Yes, folks, you heard that right. Our governor-elect Abigail Spanberger says she opposes religious organizations imposing their religious beliefs on individuals. Does that mean, Governor-elect Spanberger, that anytime that we try to enforce the First Amendment, not only of the Bill of Rights of our United States Constitution, but the Bill of Rights of the Constitution of the Commonwealth of Virginia, does that mean that every time we try to invoke the Virginia Statute for Religious Freedom of 1786, that anytime that we try to invoke that, you're going to fight us on it? That you won't sign any legislation that has anything to do with invoking a religious liberty? Folks, you heard it out of her own mouth, that our governor-elect Abigail Spanberger not only supports legislation for assisted suicide, VAIB's position is that God determines the length of a person's life from the moment of their conception until the moment of their natural birth is decided by our Creator, Jesus Christ. But you heard Abigail Spanberger say that she would support legislation that would legalize assisted suicide. And folks, they have the votes in the House and the Senate to get it to her desk. And she would oppose any legislation that would invoke religious organizations from forcing their religious liberty on any individual. Well, that's what she said. And so we have quite a battle, but God is for us. And so therefore, no power that stands against our God can win the battle. Paul said in Romans chapter 8 that we are more than conquerors through him who loved us. And so we look for God to win the battles. And you say, well, brother, you're applying something spiritual to politics. Well, we need to remember that God ordained three institutions: the family, the church, and the government. And he wants us to be involved in all three. And so I have no trouble at all with the promise of being more than a conqueror politically. But this past Monday, November 17th, was the first day that legislators in both the House and the Senate could begin dropping their pieces of legislations that were going to be introduced this coming session. The session actually starts on January the 14th of 2026. It's the even year, so it's a 60-day session this year. And so they began dropping their legislation this past Monday. And I've been reading this legislation, been traveling and reading and traveling and reading. And in fact, when I was going down to the Capitol this morning, I got involved in a backed up traffic with a vehicular accident. And then on the way home tonight, trying to get to the studio, I was in backed up in traffic with another accident, and I began to pray for those people involved in that accident. But I was also very thankful. Last year, my wife and I drove about 50,000 miles for the VEIB. We go to every corner of this Commonwealth. Now, we weren't together for all those 50,000 miles. In fact, unfortunately, most of those 50,000 miles we were not together. But I began to be reminded of the safety God has granted to us, and that if you've seen our promotional video, that's one of the things that we pray and ask God for, that He would grant us protection, because we travel a whole lot. So we're very thankful that the Lord has given us protection, and I was just reminded of that. But I want to take a trip with you tonight, looking at some of the legislation. Some of it hasn't come yet as far as a bill. Some of it is that's still in the draft mode at the fourth floor of the General Assembly building at the Division of Legislative Services. And some of these things have already come. But I want to go over with you tonight some legislation that we have seen, some legislation that we're going to see in this coming session. The first one that I want to look at with you tonight is going to be what we call the second look resentencing. Second look resentencing. The Democrats, here's what they want to do. They want to reopen finalized criminal sentences years later. Now, they've tried this before. Senator Creed Deeds from Charlottesville back in 2024 brought Senate Bill 427, and Delegate Ray Cousins from Henrico brought House Bill 834. They both failed. They both were left in appropriations. Well, the Senate bill was left in appropriations. I can't remember where the House bill was left, but they both failed. But they're trying it again, and they want to force the courts to reopen criminal investigations or criminal sentencing, not the investigation, criminal sentencing years after the sentencing has already been given. I was in a committee meeting yesterday. It was the Autism Advisory Council. And, that was one of those committees that you kind of wonder as you go, what am I going to hear? What is going to be important that I'm going to take away from this committee meeting? And one of the things that I took away from this committee meeting was right at the end of the committee meeting, Delegate Cohen brought up this second look. She says, I'm not sure who's going to carry it, but we've got a second look legislation coming, and we really need to consider that with people who have autism. Now, I understand the fact that autism is a real situation, but at the same time, it's not a get out of jail free card. And I'm afraid that what the left is going to try to do with this piece of legislation is they're going to try to open the door perhaps a little bit too wide on those people that are autistic. Now, I have people that I go to church with that work with autistic children, and so I understand that it's a real issue. But like I said, it is not a get a jail out of free card, because keep in mind that autism is not diagnosed by a scan or blood work or anything like that. Autism is diagnosed by observation. One of the ways, main ways, is by observation. And so if they open this door and allow for autistic people to receive reduced sentences or no sentences based on their autism, then what you're going to see in the Commonwealth of Virginia is a proliferation of people who have autism, because that's what people will do. And so that's kind of what I took away from that committee meeting. But on that second look, whether it's an autistic person or whether it isn't, and our hearts go out to people with autism, they really, really do. But like I said, it's not a get out of jail free card. And so you can't go and beat someone or go and murder someone and claim that you did it because you have autism. But I'm afraid that that's where the left is going to try to go with this second look sentencing. In this second look sentencing, folks, the left has a major constitutional issue that they're going to have to battle. First, it's a violation of Article 3 of the Constitution of the Commonwealth of Virginia. That's a separation of powers. And then it's a violation of, well, I'll get to that. I'll get to that violation and that number in a little bit. But I want you to recognize this. Article 3 of the Constitution of the Commonwealth of Virginia lays out the three branches of government. Whenever I have an opportunity to teach my constitutional law class, first day of class, the first question I ask the students is, name for me the three branches of government. And some of them are able to do that. Most of them are not, depending upon their past history of government. But then when I ask this question, of the three branches of government, the executive, the judicial, and the legislative, which one is the most powerful? And without fail, every time that I've asked that question, the answer that I've been given is executive. Well, that's that's wrong. That's probably the least powerful. The most powerful is the legislative. And of the legislative, the most powerful would be the Congress, because they hold the power of the purse. And I think we went over that last week a little bit in our podcast. But Article 3 of the Constitution lays out the three branches of government: the executive, the judicial, and the legislative. In fact, the Constitution says the legislative, executive, and judicial departments shall be separate. This is a quote from the Constitution: shall be separate and distinct, so that none exercise the powers properly belonging to the others. The Constitution of the Commonwealth of Virginia clearly lays out two issues on the separation of powers. Number one branch cannot perform the duties of the other two branches. Number two, you cannot be a member of more than one of those branches, meaning that a judge who's a member of the judicial branch cannot be in the House of Delegates or the Senate, which is a member of the legislative branch. But in addition to a violation of Article 3 of the Constitution, it is also a violation of Article 5, Section 12 of the Constitution, which says this: the governor shall have power to remit fines and penalties under such rules and regulations as may be prescribed by law, to grant reprieves and pardons after conviction, except when the prosecution has been carried on by the House of Delegates, to remove political disabilities consequent upon conviction for offenses committed prior or subsequent to the adoption of the Constitution, and to commute capital punishment. Now, according to Article 5, Section 12 of the Constitution of the Commonwealth of Virginia, only the governor has the authority to change, remit, or commute punishments, not the General Assembly. Now, let's go back to that article where it says that in that quote that when the prosecution, after the prosecution, except when the prosecution has been carried on by the House of Delegates. Now, what did the founders mean by that? Well, that's impeachment, because the House of Delegates are the ones that would impeach a governor or judges. And so what the Constitution says is that a governor can't commute his own impeachment. So if the prosecution or the impeachment came down, or the conviction came down by the House of Delegates, meaning an impeachment of a governor or a judge, Supreme Court judge, then the governor does not have the power there, but every other conviction that he would. Any person in the Commonwealth of Virginia that is convicted of a crime and sentenced, the General Assembly does not have the constitutional authority to reopen or force a court or a judge to reopen sentencing and either remit the sentencing, abolish it, or abolish it entirely is what I mean, or to lessen that sentencing. This section of the Constitution has gone under a number of revisions since the 1776 Constitution. Now, under the 1776 Constitution, the governor exercised pardon power with the advice of a council of state. Now, the 1851 Constitution abolished the council and vested the sole power of communing or sole vested the power of pardon with the governor. Now, the 1928 revision of the Constitution of Virginia made a provision for what they called a pardon board, and they gave themselves the power, the ability to create such a board, and they did in fact create a board for a very brief period of time in the 1940s. But since 1851, the power of the pardon has relied solely with the governor. Not only does the governor, folks, alone have the pardon power, but the governor alone has the power for conditional pardon. That was decided in 1872 in Lee v. Murphy when the Virginia Supreme Court of Appeals concluded, quote, the power to grant conditional pardons is vested in the executive of Virginia. And of course, the executive of Virginia is the governor. And that was confirmed in 1938 by the Virginia Supreme Court of Appeals with Wilburn v. Sanders that said, quote, the power of the governor has applied to the constitutional pardon now under consideration is not restricted by any constitutional or statutory provision. Here's the point. Article 3 and Article 5 of the Virginia Constitution says that no member of the Virginia General Assembly has the power to create a law which will allow a judge or incite a judge or a court to look at a sentencing after the sentencing had already taken place. But we're not just talking about pardons. We're also talking about judges reopening cases to re-examine the conviction. If someone was found guilty of second-degree murder and was sentenced to 25 years to life of prison, the General Assembly is trying to create a law that would allow a court and a judge to reopen that case. And very possibly, if that person had been in jail for 20 years, it's very possible that if this type of legislation would be signed by the governor, which it would be signed by the governor, that it would very possible say that 20 years, time served. And the guy gets out of prison at the end of 20 years instead of 25 to life for second-degree murder. And so that is what is different, but that is what is dangerous. But what we need to keep in mind is that commuting sentencing or changing sentencing is a judicial act, not a legislative act. Because you go back to Article 3 of the Constitution, the separation of powers. And to commute sentencing or to reduce sentencing is a judicial act and a judicial act alone. And it is not part of the legislative process. So the General Assembly, the members of the left in the General Assembly who try to patron this bill, we've already been told that it's coming. It's just a matter of who's going to be the patron of it. But they do not have the power to change sentencing once conviction has happened and the sentencing has been given. Now, the General Assembly can create procedurals for post-convictions relief, like a habeas corpus or a writ of innocence based on biological or non-biological evidence based on Section 19.2-327.1. And so what they can do is they can create procedures for the investigation. For example, there was a murder that took place many, many years ago, 30-some years ago, in a small town that I'm very familiar with that was never solved. It was back in the early 80s. And they collected some cigarettes in the parking lot of the area where the murder took place. Well, back in the early 80s, DNA wasn't really a thing, but now it is. And so what this General Assembly can write laws about is the procedure that the convicted criminal can, again, it's Section 19.2-327.1, the convicted criminal can petition the court that originally sentenced them to open the investigation based on new biological evidence, meaning, okay, now DNA is a thing. I know they collected a cigarette butt on the parking lot. Run the DNA and see whose DNA that is. Now that's just an example of what that section of the Code of Virginia would allow to take place. But the final conviction, once it is handed down by a judge or jury, the conviction is final in this regard. The General Assembly cannot change it. And that is Article 3 and Article 5 of the Constitution of the Commonwealth of Virginia. And so, as you see, based on the Constitution in 3 areas, if they try to um, bring legislation of a second look nature, they are in violation of the Constitution in at least 2 areas. And VAIB will be there to remind them of their constitutional violation. But as you've seen, and as I see every day, and as we see from Governor-elect Spanberger's speech there, folks, listen, the left really doesn't care about the Constitution so much of the time. And Abigail Spanberger, governor-elect, says that she would oppose religious organizations imposing their religious belief on individuals in contradiction to the first Bill of Rights of the United States Bill of Rights and the Bill of Rights of the Commonwealth of Virginia. But I want to go on to another one that they're going to be bringing up, and that's the eliminating of the religious exemption for homeschoolers. Now, Senator Pekarsky in Senate Bill 1031 tried to do this last year. She created a well-deserved firestorm for what she tried to do. She created a well-deserved fight with homeschool moms and organizations such as the VAIB, and who, as we went down to advocate. And basically, what the Code of Virginia says in 22.1-254, it basically talks about the fact that if you turned 5 on or before September 30th and are under the age of 18, you are required by code to be instructed to be enrolled in educational instruction unless you have a, quote, bona fide religious training or belief. Again, that's code 22.1-254 of the Code of Virginia. Now, section 22.1-254 subsection B-1 states this: any pupil who, together with his parents, by reason of a bona fide religious training or belief, is conscientiously opposed to attendance at school. For purposes of this subdivision, bona fide religious training or belief does not include political, sociological, or philosophical views or a merely personal moral code. Now, 22.4-251.4 is the declaration of the policy, is the requirements of homeschool children. Again, it says, quote, nothing in this section shall prohibit a pupil and his parents from obtaining an excuse, and this is current code, from obtaining an excuse from homeschool attendance by reason of a bona fide religious training or belief pursuant to subsection B-1 of section 22.1-254. Both of these sections, 22.1-254 and 22.1-254 subsection B1, both of these sections were removed from Senator Pekarsky's bill. And it basically stripped the Code of Virginia 22.1. It basically stripped the Code of Virginia of any right of a parent to educate their children based on a bona fide religious training. And so we fought that. Now, does that violate the Constitution of Virginia? Oh, yeah. Oh, yeah. In fact, the religious liberties that are afforded to the citizens of the Commonwealth through our Constitution are stronger than the liberties afforded to us by the Constitution of the United States. Here's Article 1, Section 16 of the Constitution of the Commonwealth of Virginia. quote, all men are equally entitled to the free exercise of religion according to the dictates of their conscience, nor shall otherwise suffer on account of his religious opinions or beliefs. The section also goes on to say, which again is a little bit broader than even our nation's constitution, because the section, Article 1, Section 16, goes on to say that you can't even be stopped from holding a civil job based on your religious beliefs. You have absolute freedom and absolute autonomy in the Commonwealth of Virginia to practice your religion by the dictates of your conscience. And folks, that includes the education of your children. Now, this bill, SB 1031, that Senator Bukowski gave last year, would be introduced. It'll be a different number. May even be. I've gotten wind down into the Capitol that it's going to be a different patron. That they're not going to. I think Senator Schuyler Van Valkenburg may be carrying it this year, but we're not sure because it has not dropped yet. But it does not hold, folks, to the scrutiny of the Constitution. The Constitution of the Commonwealth of Virginia guarantees freedom of religious practices, and those practices involve the religious training of your children by homeschooling them. Church, folks, listen. The state is not responsible for educating your children. Parents are. Parents are. And you can't, by a stroke of a pen, the members of the Democratic Party of the House of Delegates and the Senate cannot legally, I'm not saying they're not going to try, they cannot legally, with a stroke of a pen, take away religious liberties that not only our Constitution of the United States give to us, but more broadly, the Constitution of the Commonwealth of Virginia gives to us. And so VAIB will again be there to remind our leaders of what the Constitution says. I want to remind you of something that was said. Let me remind you, let me give you a couple quotes about the Constitution. I like what James Madison said. James Madison was considered the father of the Constitution. And he said in the Federalist, if you've never read the Federalist Papers, you need to read it because the Federalist Papers was written it's good insight. Whether you're a Federalist or a non-Federalist, to read the Federalist Papers is good insight because it lets you know what the Founding Fathers were thinking of why they believed the Constitution was a good idea. Now, keep in mind, the Federalist Papers was written prior to the inclusion of the Bill of Rights. So James Madison, who's known again as the father of the Constitution, said this in the Federalist number 51, specifically about the Constitution. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and then in the next place, oblige it to control itself. In other words, James Madison, the father of the Constitution, says, listen, the purpose of the Constitution is not only to rule or not only to direct the governed, but to keep in check the governing. The lawmakers in Richmond, in Washington, are not above adherence to the Constitution. Thomas Jefferson, in his Kentucky Resolution draft in 1798, said this, quote, the questions of power, let no more be heard of confidence in men, but bind him down from mischief, get this, by the chains of the Constitution. Thomas Jefferson said, you know how do you control your lawmakers? By the chains of the Constitution. John Marshall, who was the Chief Justice during that very famous Supreme Court case, Marbury versus Madison in 1803, said this, quote, the government of the United States has been emphatically termed a government of laws and not of men. And then one final quote from a great man, Ronald Reagan, said this, quote, the American Constitution is unique, Most constitutions of the world are documents in which the people grant rights to the people. Our Constitution is a document in which, quote, we the people, end quote, tell the government what it can do. It is a charter of liberty for the governed and a charter of restraint for those who govern. The delegates and the senators in Richmond are not above the Constitution of the Commonwealth of Virginia. They're certainly not above the Constitution of the Commonwealth of Virginia. And the Virginia Assembly of Independent Baptists will be there on the ground, reminding them of the Constitution. The third area that we're seeing coming is they're going to make semi-automatic rifles and 10-round magazines illegal to possess. So all you AR-15 owners, they're coming after them. All semi-automatic rifles and 10-round magazines are going to be illegal to possess in Virginia. Now this is not even going to be a buyback. This is going to be, because sometimes the left will say, okay, bring us your magazines, bring us your guns. We'll pay you the value of them that the value is right now. This is not even a buyback. This is a total confiscation with no grandfather clause, meaning that if you own them, you can keep them. You just can't buy new. It's not even going to have a grandfather clause. Is it constitutional? No way. Not even close. Article 1, Section 13 of the Constitution of the Commonwealth of Virginia, quote, that a well-regulated militia composed of the body of the people trained to arm is the proper, natural, and safe defense of a free state, comma, therefore, comma, the right of the people to keep and bear arms shall not be infringed. Question: does a Harry homeowner have the right to have a magazine that will hold 15 to 25 rounds of bullets? Yes. You know why? Because Article 1, Section 13 of the Virginia Constitution says that those rights to have those things shall not be infringed. I was notified today that they're trying to pass legislation in this session coming up that you will have to buy a license before you can get a license. You will have to buy a license. You'll have to give the Commonwealth money before you can even get a license and carry a gun and buy and purchase a gun. Folks, listen, I call having to buy a license to get a license, I call that an infringement. I call that an infringement. The United States Supreme Court in 2022 made a landmark decision in New York State Rifle and Pistol Association v. Bruen in a 6-3 ruling. Clarence Thomas wrote his opinion that dramatically expanded Second Amendment gun rights, because for the first time, the court explicitly held that the Second Amendment, protects the right of law-abiding citizens to carry handguns for self-defense. Now, here's what Bruen did. Bruen requires the ruling that the Supreme Court made require two things. Number one, in order for new laws to be passed, and this is from the Supreme Court, in order for new laws to be passed, they have to be presumed unconstitutional. The new laws are presumed unconstitutional unless the government can prove two things. This is what the ruling in 2022 by the Supreme Court said. If these two things can be proven by the new law, then you can make that a law. But in order for new laws to become intact, two things have to be proven. Number one, the Second Amendment's plain words cover what the law is trying to restrict. Okay. Does the Second Amendment cover the restriction of 10-round magazines? No. Does the Second Amendment cover the restriction of semi-automatic rifles? No. It's two. There has to be strong historical tradition of similar laws by the time of the Second Amendment, which was in 1791, or the 14th Amendment, which was in 1868. Now, I'm from rural country, so I'll give it to you like my gun carrying friends in my rural part of the Commonwealth say it. No made up modern rules just because they sound good today. If you want to ban or heavily restrict something gun related, show me where early America did something pretty close to the same thing. If you cannot find a good historical example, or at least a close one, then the law gets thrown out. That's how they say it in my neck of the woods. Looking at my producer over there. That's how they say it in my neck of the woods. This kind of law fails miserably because the restrictions that they're trying to bring forth are not covered under the plain language of the Second Amendment. And there is no historical example of this being restricted. And so, again, the restriction of semi-automatic weapons and 10-round magazines trying to make their possession illegal does not hold against the scrutiny of the Commonwealth of Virginia. Number 4, and we're getting to the end because I've got about 15 minutes. Number 4, forcing schools to teach gender ideology without parent opt-outs. Now, what is that? That a school can teach your son or your daughter about gender dysphoria and about gender transition without parental knowledge or the ability to opt out of such classes. Folks, let me tell you, the state cannot compel children to receive instruction that conflict with their family's religious beliefs. And while at the same time denying the parents the right to opt out. This bill violates Article 1, Section 16 of the Constitution, which is the exercise of religious freedom. And it violates Article 1, Section 12 of the Constitution, which is freedom of speech. And it violates Virginia's statutory parental right laws of 1-240.1, which clearly states this. This is section 1-240.1, clearly states as a parent has, this is a quote from our statute, a parent has a fundamental right to make decisions concerning the abridging, education, and care of the parent's child. Now, where does code say who has the authority? The parents, not the state. Now, here's a fear that we've got. When I was called back to reconvene session back the first of the month, about a week before election, to talk about the shenanigans of getting back into gerrymandering, where the left is trying to change a constitutional amendment that was voted on by greater than 65% of the people of the Commonwealth of Virginia back in 2020, and they want to change it where we voted in a constitutional amendment that would have created a redistricting board. They want to give the power back to the General Assembly. If another state, because redistricting happens every 10 years. The last redistricting was in 2021, so the next redistricting would be in 2031. But this amendment would give the legislatures and the General Assembly the power to take the redistricting reins themselves if another state redistrict within those 10 years, which other states already have. And so if this passed, they would immediately start their redistricting. And they said, "Oh, we're in a emergency." Well, I got into a little constitutional sparring match with Senator Scott Surville from Eastern Fairfax, reminded him of Article 12, Section 2 of the Virginia Constitution that said that in order for there to be a constitutional amendment, it has to go through 2 sessions with an election in the middle. I said, Senator, I said, we're not in an intervening election. We've been in the intervening election since September the 19th. The next intervening election would be 2027. And so you are in violation of the Constitution, Article 12, Section 2, in trying to do this. But you're also in violation of the code, the statute of 30-13. Code 30-13 states this, that the clerk of the Senate has to send 2 copies of the proposed amendment to every circuit court in the Commonwealth of Virginia 90 days prior to the election. Well, that didn't happen either. The answer I got back from Senator Surville was, well, that was removed from the Constitution in 1971. And even, okay, it may have been removed from the Constitution in 1971, but it is still in code. And the Constitution does not explicitly strike down or repeal the code. His answer was, well, the Code Commission is going to get rid of it this coming session. So if the left just doesn't like something that the code says, we'll just get rid of it. We'll just go to the Code Commission and we'll just tell them to vote to get rid of that. We'll just repeal that part of the code. Folks, I want you to understand that they could easily do that to our religious liberty by code. Now, they can't get rid of it in the Constitution, but they could get rid of Section 1-240.1, which basically states that the parents have the right to educate and raise their kids. They could get rid of that code with just a stroke of a pen, because it's code. And what I learned by that discussion with Scott Surville is he doesn't know the Constitution as well as he thinks that he does. But another thing that I gained from that conversation with Scott Surville is that they have no problem in the world getting rid of code if it doesn't suit them. Folks, we got a lot of things to pray about. And I've already seen legislation. This piece of legislation has dropped that will get rid of the right to work state in the Commonwealth of Virginia, that there will be some jobs that you cannot do unless you are part of the union. Now, interestingly enough, the patron of that bill is Senator Jennifer Carroll Foy. And I thought for a moment, I said, I wonder how much money she received from the union in her last election. Well, she ran for governor. She didn't win the primary, but she ran for governor in 2021. Her campaign received $350,000 from the Teamsters, from the union. $350,000. That's no small chump change. And so this is quid pro quo written all over it. You scratch my back, I'll scratch yours. You get me elected, I'll put legislation in, and our governor will sign it, by the way. She's already said that she'll get rid of a right to work. You get me elected, and I'll put forth legislation that will force people to have to join unions. Now, people want to claim, well, unions create a safer work environment. They do this, they do the other. And while some of that may be true, no one should be forced to have to join a union against their will. And then they say, well, nobody's forcing anybody. Yes, you are. If I'm a non-union electrician working on a job site with the union, in order for me to stay on that job site, I would have to pay the dues and join the union. That is forcing people to join the union. That bill has already dropped. We've already seen a contraception bill drop that's going to force religious organizations who have a conscionable objection to contraception to pay for, through their health care plans, or contraception of other people. Now, VAIB doesn't take a stand on contraception, non-abortive contraception. We think that that's a decision between a husband and wife and God. But we do take a stand on this. I'm not paying for it. People shouldn't have to pay for it. That violates the Religious Freedom Restoration Act of 1993, that basically says that the government cannot substantially burden a religious organization that violates their conscience. Yes, folks, the left has to be reminded of law, because I really do think that many people on the left think that they are above the law, that think they can create any law they want just because they're a delegate or just because they're a senator. VAIB is there to remind them. This is what the Constitution says. Number one, this is what the Bible says. This is what the Constitution says, and this is what statute says. We've also seen a piece of legislation drop that will require that no plea agreement can include a waiver of Fourth Amendment rights. And of course, the Fourth Amendment basically is an amendment that against unlawful search and seizure. Basically, what it says is basically what's happening now is if somebody is charged with a drug possession or drug sale, distribution, or whatever, drug trafficking, whatever, then the Commonwealth attorney can say, okay, we will give you a deal, but you have to waive your Fourth Amendment rights for a period of 10 years or maybe the rest of your natural life, so that they could come to your home, your car, and search your home or car without a warrant and without reason. The left doesn't like that. But in a 5-minute search on the internet, I found a plethora number of cases where Commonwealth attorneys have given that same exact deal to drug users and drug traffickers. And when they went back unannounced and searched their home or their car, guess what they found every time? Drugs. If you don't have anything to hide, you don't have anything to hide. And so that's also coming down. I'm probably going to meet with the senator that's patronizing that, just because he and I have a pretty good relationship. I don't know how VAIB. I'll call some pastors, and after I meet with the senator, I'll call some pastors and see how they would suggest that we proceed in that. But that's just another bill that's come down. They've also included a bill that's going to increase the minimum wage to $15 an hour by 2028. That was vetoed last year by Governor Youngkin. Also vetoed the year before by Governor Youngkin. Because what good does it do you to get $15 an hour at 30 hours a week? Say you're making $10 an hour and working 30 hours a week. What good does it do you to make $15 an hour, but in order for your employer to save himself money, he's cut your hours to 10? You're probably going to be making less money. So it will substantially and unnecessarily burden struggling business owners in the Commonwealth of Virginia. Well, we've got a lot to fight in Virginia in the General Assembly, but the Virginia Assembly of Independent Baptists is actively involved in fighting and standing for your religious liberty. We want you to stand with us. I would encourage you, give me a call and let me know what you think. When you go on YouTube or you go on Facebook, be sure to subscribe and be sure to hit that bell so that you're notified whenever a program hits the internet, hits YouTube or Facebook. I want you to give me a call. I want you to let me know what we can do to help you, what you think about what we're doing, how we can do things differently. Call me 804-960-4014. That's 804-960-4014. Or you can email me at director@vaib.org. Well, the Virginia Assembly of Independent Baptists has a lot to do. We tonight have put the General Assembly on trial, and we have found that the left of the General Assembly is guilty of a violation of the Constitution of the Commonwealth of Virginia. I want to remind you of our rally, December the 2nd, from 1 p.m. to 3:30 p.m., 8659 Staples Mill Road in Henrico, where we're going to unite together and encourage one another in the Lord, and try to remind you of some new things that we've discovered that are going to be going on. And we appreciate your prayers as we prepare for that rally. Pray for the VAIB as we go down to Richmond most days, and we meet with senators. I sent out an email today to every one of the new delegates, both Republican and Democrat, because I want to meet with them and discuss with them some legislation that's going to be coming this coming session. So you pray for the VAIB. We want to glorify the Lord Jesus Christ in everything that we say and do. We want to remind them of what the law says. They need to be reminded. but we want to glorify and honor and magnify the name and the person of the Lord Jesus Christ. So you pray for us. We'd also invite you to come down to the Capitol with us. We'd love to walk the Capitol floor with you. We'd love to go into session with you. We'd love to be able to go into committee with you to show you how the process works. The process is absolutely fascinating. We'd love for you to watch it. Just give me a call, 804 960 4014. That's 804 960 4014. And just let me know when you'd like to come, and we'll meet together, and we'll walk the floors together. We'll meet some delegates and senators, and you'll learn how the process goes. Well, I thank you for joining us tonight, and I hope this has been informative for you. And I know that I have enjoyed, as I read the Constitution and as I read the Code of Virginia, I enjoy dissecting these laws to figure out what exactly the left is up to. So you pray for us that God would continue to give us perception, not only of how these bills would negatively affect the church today, but how these bills would negatively affect the church tomorrow. Thank you very much for joining us. We appreciate you being here. God bless you, and we'll see you next time.